We are honored to have our dean with us, Associate Professor Dr. Suphasit Taweejamsup. He is kindly accepted to be giving this opening speech and opening remarks today. So without further ado, please allow me to welcome Dr. Associate Professor Dr. Suphasit Taweejamsup to give an opening remark. Thank you.
Thank you so much, Mr. Yok. Distinguished guests, colleagues, students, and friends, and good afternoon and welcome to Faculty of Law, Chulalongkorn University. I'm pleased to open today's seminar, Law and Economic in Practice. From my experience in labor law and legal education, I have seen that modern legal works needs more than legal theories. Complex cases today rely on data, evidence, and economic reasoning. However, in Thailand, economic is still rarely applied in legal practice, whether in courts, arbitrations, or regulations. This is why today's seminar is both timely and important. We are honored to welcome Dr. Kristofer Hammarbäck, Vice President of Compass Lexecon London, one of the world's top economics consulting firms. Compass Lexecon advised government, law firm, and major corporations worldwide on competition law and regulatory cases. Dr. Hammarbäck will share insights from EU and UK competition law. In his talks using economic in law, lessons from competition law enforcement. He will present real case studies where economics analysis was key in mergers, antitrust, and damage litigations. With his PhD economic from Oxford University and experience work with major companies like IBM, Google, and JD Support, Dr. Hammarbäck combines theory with real-world practice and showing how economic and law work together in solving complex cases. And for Thailand, as our competition law goes and courts face more complex disputes, learning from international practice is essential. This seminar helps us see how law and economic can support one another. I would like to thank a lot Assistant Professor Dr. Peerapat, Chokesuwattanaskul for organizing this event, and extend my warm gratitude to Dr. Hammarbäck again for joining us in Bangkok. And I encourage you all to engage, ask questions, and consider how this idea may enhance your own work. Thank you very much, and wish you an inspiring this wonderful afternoon. Thank you.
All right. So thank you very much, the Dean, for the opening remarks. Well, I can say so much about Dr. Kristofer, but his expertise is just apparent. Education-wise, he got PhD in economics from University of Oxford, one of the, well, the great one. Yeah, and we're going to learn a lot from his experience, which I think I would leave it to him to really cover what he has done, what he's up to, and what he is aiming at doing from this point forward. But another thing that I really want to show my appreciation is, and also to tell you, Chris, is that this very field, both in terms of academics and in terms of practice, is something that is still pretty much in a very infant stage here in Thailand. And that is pretty much the whole purpose why I invite you. And thank you very much for accepting to be a part of this. So yeah, I look forward to learn so much from you, from your experience, from your wisdom. And then I will see you in roughly an hour or so, and I will ask you about things, not just about what you're going to present to us, but also about this particular practice of law and economic consulting in general as well. So the floor is yours. Thank you very much, Chris. Please.
Okay, thank you very much. Thank you very much for having me here, and thank you very much, Yok, for the invitation. I've had very interesting discussions with Yok about the intersection between law and economics, so I'm glad we could finally make this happen. And I'm also very glad to hear that a Cambridge graduate are calling Oxford a great university, so kind for those words. And also slight apologies, we are a little bit late because apparently there is traffic in Bangkok, I have realized, but we're here now. All right, so I'm quite excited to be here to talk about the intersection between law and economics, which is an area which is very close to what I do and what I find very interesting. So I hope we can touch on some interesting issues as we go through today and also in the discussion afterwards. So just to give an introduction to what I will be covering in this talk is that I'm going to be focusing on competition law, which is the area of law in which I would operate. So I'm an economist, so I'm using economic techniques within the area of competition law. Now, economics is very, very central to competition law for various reasons. So first of all, the substance of competition law is inherently economic. Okay, competition is about making sure that companies compete to produce good outcomes for consumers in markets. Okay, that is economics. It's an area of economics called industrial organization, and so by its very nature, economics is at the heart of what the topic is about. And what that means is when you have proceedings that involve competition law, the type of evidence you want to bring forward really requires economic evidence, it requires economic expertise in order to bring effective arguments. So it's going to be natural that economics plays a very central role. And this role in the EU and the UK has been very strongly increasing over the last decades. And that's both because of regulatory developments that have made it more effective to bring economic evidence in competition law enforcement, but also because economics has developed. Technology has developed, which has made it more easier to bring economic evidence. So I will be discussing what we do within competition law, and then hopefully also touch on what that can tell you about lessons for other areas of law where economics might play a role. So that's what I'm going to go through in this talk. So just to give a heads up on structure, so I will start off by giving a high-level overview of what EU competition law is. So if you're familiar with the area, this might be repetitive, but otherwise I hope it's a good kind of introduction and context to the framework in which I apply economics. I will then go through sort of more practical examples of how, in practice, we actually use economics in practical enforcement and what that actually looks like, and go through a couple of actual studies that I worked on myself. And then more briefly at the end, I'm going to just comment on the more recent trends and developments of how the field is currently developing, and kind of takeaways for how economics can add value to legal practice. Okay, so really try to see this intersection between law and economics and how that can play out. All right, and then, so Jok already briefly introduced me, but just to kind of cover that, so I have my PhD in economics from Oxford, where I was focusing on exactly the area of industrial organization, which is the area within economics which is relevant for competition law. So after my PhD, I've gone into economics consulting, where I'm now an economic consultant at Compass Lexecon, based in London. And what we do is that we advise law firms, companies, and authorities on economic advice in relation to competition proceedings. And that can involve providing expert testimony and reports. So we might go to court and testify about economic issues. We might write reports that get submitted to authorities, where we opine based on our economic expertise, what we think that the answer is in the relevant cases. Okay, and I will go through in more detail what that actually looks like as we go through. And then the list there is a couple of cases I've actually worked on, some of which I will be discussing. And there you can see the different areas within competition, which I also will touch on in more detail shortly. All right, so just to give an overview of EU competition law and what that looks like, which then is the kind of cases where we would then apply economics within. So this slide is very ambitious because it tries to summarize the key parts of EU competition law in a single slide. Now, I hope at least it can give the main flavors. So the three key areas within competition law, at least in Europe, is Article 101, 102, and then the merger regulation. So Article 101 is about agreements between companies. So if the idea is for competition to have firms competing against each other to produce good outcomes for consumers, it's quite natural that we shouldn't allow them to make agreements between each other not to compete. Okay, that is completely opposite to the purpose of competition. So therefore, it's very natural that we have an Article 101 which prevents anti-competitive agreements between firms. In US competition law, this is the Sherman Act, which is the equivalent of it. So that prevents firms from making agreements between each other that prevents them from competing effectively. This can typically be grouped into by object or by effect infringement. So by object infringement are cases where it's just so obvious that this is bad for competition that we don't need to prove whether it actually had any effects. Then there are other cases where the more of a gray area where you might actually need to prove whether there was an effect from the conduct. And as you might suspect, it is the by effect cases where economics comes in particular. Also in by object cases, but in particular in by effects, because you will need economists to prove whether there was effects or not. So in the more kind of gray areas, you will really need economic evidence. So anti-competitive agreements can involve cartels. So there's the famous vitamins case, which was an obvious cartel. There were information exchanges. So there's the air cargo case, where airlines were exchanging information about surcharges they were pricing to customers. And there are many other types of a bit more gray areas. So one interesting area is cooperation agreements and sustainability agreements. So sometimes there can be companies that get together and try to make sure that they are producing things more efficiently from a green perspective, so reduce carbon emissions. But they got to be very careful, because if they talk to each other to make sure they align standards and make things more sustainable, that can also fall under the prohibition of anti-competitive agreements. So this is a very hot debate right now within competition law, how to encourage sustainability agreements, but without making sure they're illegal under Article 101. So that's the first main area. The second main area is Article 102. So this is the abuse of a dominant position. So this is when a very large company that has a lot of market power abuses that position. So if a firm has dominance, it can take actions that prevents effective competition, and that is also against the purpose of competition law. Now, I think it's important to keep in mind that it's not illegal to be dominant. Okay? If you're good enough that you deserve to be the biggest company, that's fine. Okay? But what is not fine is that once you become that dominant company, that you then do things to prevent competitors from competing against you. And that's where the prohibition comes in. So famous cases in this area is Microsoft Media Player. So this was way back in the beginning of Microsoft and Windows, where they bundled Media Player with Windows. So when you got Windows on your laptop, you automatically got Media Player. And because Microsoft imposed that, it was very hard for other media players to compete, because everyone who had a laptop or a computer already had Media Player. Okay? And that was found to be an abuse of a dominant position. That they were not allowed to do that because that prevented other media players from having a chance to compete. And we now also see similar cases in app stores, and Apple on their phones, they might pre-install some apps, which might then make it harder for others to compete. There's a famous case on Intel, which I will actually discuss later, and Google Shopping is the one where Google was listing their own shopping services highest up on their search pages. And the third main area is mergers. So there is a prohibition on firms merging when there is a risk that that merger creates harm to competition. We typically classify this into horizontal, vertical, or conglomerate mergers, where horizontal are two firms that are in the same market that are merging. Now, it's quite obvious that can create issues, because if two firms that used to compete with each other will no longer do so, that can reduce competition. A vertical merger is when one firm sells to the other firm, in which case it's slightly less concerning in general, but there can be issues about foreclosure, which is when one firm decides to then stop providing to competitors to the firm that it's supplying to. And finally, there is conglomerate mergers where the firms are not in the same market, but there can still be issues in case of bundling and tying between the markets. So when one firm is dominant in one market and then say, you can only buy this other product if you also buy my dominant product, and that can prevent competition in the other market. And not every merger needs to go through these regulations, because to keep workload manageable for authorities, only large enough mergers need to go through this regulation. This is also a very hot topic right now, because there is these theories of killer acquisitions, where the big tech firms more generally are buying small startups, which doesn't have a lot of turnover, so they don't fall in this regulation. But can be harmful for competition, because the big tech firms, the theory would be, are killing off these small startups before they become a threat. So that's another hot topic in this area. So these are the key 3 building blocks, which then are the cases that we would be working on. A bit more quickly covering through the other area. So a very recent development is the digital ex-ante regulation. So it's recently become clear that digital markets were developed very quickly. So they're very fast-paced, products develop very fast, and ex-post enforcement, so the rules I just discussed, take a lot of time to enforce. It can take many, many years from an investigation to start until you have a judgment. And by that time, the market have completely moved on. So therefore, both in the EU and the UK, there is now ex-ante regulation. So these are rules that set out precisely how digital firms are allowed to act. And that is enforced in real time rather than after the fact. And it's just quite interesting for those who's interested in this area to look into, because the EU and the UK has taken very different approaches to this. So the EU has a very fixed set of prescribed obligations. So they set out very strict codified rules for how the digital platforms are allowed to act. Whereas the UK version is way more bespoke, and they tailor each requirement to each firm. And this is very much a recent thing, still developing, and I think it's very interesting to see which system is most effective. What we can say so far is that the UK version seems to be taking a lot of time for the authority, so they haven't gotten very far, whereas the EU version is up and running already. So that, in that way, the EU won, but we'll see with time how that develops. There are other areas as well I'm not going to cover in any detail or at all. One which is state aid. So it's illegal for a country to give support or subsidies to a firm that then distorts competition in favor of that firm. This has been issues in particular in airports in Europe, where small regions would often give support to have an airline come to their local airport, but that distorts competition and break these rules. Sometimes an authority might make a market investigation when they're concerned about competition within a certain market, which is not in the context of any of the rules we just discussed, but they are just generally concerned. And there's a more recent regulation which is in foreign subsidies, that the EU is concerned that foreign governments are subsidizing firms within the EU, which is very recent, and is increasingly economists are getting involved in this work. So these rules can be enforced both in public enforcement and private enforcement. So public enforcement will be when the authorities are enforcing these rules, which, you know, economists would be involved in those proceedings. And in particular in private enforcement, so when private parties are bringing suit in national courts on the basis of the competition rules. So this EU damages directive was a rule change, I can't remember how long, 15 years ago maybe, 10, 15 years ago, which made it a lot easier to bring actions, because the damages directive said that if the European Commission or a national authority has found an infringement of competition law, then you can use that to bring damages suit in court. You don't need to prove an infringement from start. And that made it a lot easier and has massively increased the amount of damages proceedings and work for economists. So it's had a really big change on the industry of economic consulting. And then just briefly, Brexit very much has an impact on competition law enforcement. It used to be that the UK and the EU had the same rules after Brexit. That's no longer the case. So law that was done before Brexit are still applicable in UK courts, whereas subsequently to Brexit there is divergence, and this definitely have an impact on how things are being enforced. And the digital regulation is one example. There's also in mergers, the UK and the European Commission is taking very different approaches to the frustration of merging companies. Okay, so that was an overview of the law side of things. And now I'm going to touch more on how economics is being applied and used within these areas that we just discussed. So I'm going to walk through abuse of dominance, mergers, and litigation, which is probably the main areas in which we would work. So within abuse of dominance, the assessment is always two-step. So the first step is to find whether a firm is dominant or not. The main analysis here is market shares. So if a firm has a sufficiently high market share, there is a presumption that it is dominant. So this really is the main key step. And whenever you need a market share, you probably need an economist. So this is where we spend a lot of work on collecting data, trying to figure out what is the boundaries of the market. So what is inside the market and what is outside the market, and then try to calculate market shares. So a market share really is just one number, a numerator, divided by another number, the denominator, but it's a lot more work than that. That goes into it. So this really is the central part of the work that we would do in these proceedings. Market shares is not everything though, so usually you want to calculate your market shares, but you also want to go behind them and think about how does the market actually work. So in particular, if a firm has a very large market share, but the market is contestable, so if competitors easily could swoop in case the firm tried to raise prices or tried to do something anti-competitive, then even if there's a large market share, the firm will not be dominant because it can be constrained. Likewise, market shares are not always the full story. So in particular, if you're looking at tender markets, where you don't have products which are frequently sold, but rather big contracts that represent a large share of the market, then just a single project win can massively impact market share. And then market shares may not be reflective of actual competition that happens in the market. So you got to kind of go behind the hood of what's actually going on in the market. And then you look, if the firm is found dominant, you then look at the conduct that is being investigated and try to figure out whether the firm has abused that dominant position. And here it's very context dependent. It depends on what kind of conduct it is, but generally economists would be involved here to try to understand whether the conduct could harm competition and harm competitors. So I'm going to cover one example of that now. So this is the Intel case. So I did not personally work on this case. All the other cases I discussed I have worked on. I have worked on similar cases to this one, but that I can't discuss for confidentiality reasons. But I'll cover this to give a flavor of the type of work that is being done in abuse of dominance. So this is a case originally from 2009 and has then been appealed for eternity. It's been appealed many, many times and it's gone circles through the system. So that's why it's a very famous case. I think it's finally over very recently after 15 years of appeals. But in 2009, the European Commission found that Intel had a dominant position. I think these days it might not, because it's not as strong as it used to be. But at the time, it was found to have a dominant position in certain processing chips. and that he had abused that position by offering excessive loyalty rebates. So loyalty rebates are something which is quite suspicious from a competition law perspective. Because a loyalty rebate is when you give a discount for higher quantities. And the discount is not just on the extra units that you get, but also if you buy a very high amount of units, you get discounts on the first units that you bought. So what that means is that they give a very strong incentive to the customers to either buy nothing or buy everything from Intel. So it's kind of an either-or situation because of the structure of those discounts. Now what that means is that when the customers, so here Dell and HP, so computer manufacturers, when they decide whether they're going to go to Intel or AMD, which is pretty much the only competitor at this time, they basically have to decide either Intel or AMD. They can't mix, they can't do both. And given Intel's very strong discounts, it's going to be hard for any customer to say, okay, we're going to go AMD. Intel just looks too attractive, and they can't mix, they can't give some demand to AMD. And that means that AMD never gets a foothold in the market at all. So this is very suspect. So this is a case of what we call predatory pricing. So these are prices that are too low. Now this may sound a bit strange from a competition law perspective, because we generally want prices to be too low. But in this case, the harm would be that it prevents AMD from even entering the market and become more efficient and be able to create competition to Intel. And the way this becomes assessed in practice is that the legal test is essentially the as efficient competitor test. So what you do is that you think about a hypothetical competitor to Intel that would be as efficient as Intel is. So the same cost structure, the same efficiency as Intel, and say, if that other competitor had existed, would it have been able to survive in the market when Intel is pricing the way it does today? And to test that, you then collect data from Intel. You collect data on the prices that it's charging. You collect data on the cost. So cost may sound like a simple thing to just count numbers. Okay, it's not. It takes a lot of time and a lot of thinking. In particular, because what is long run and what is short run. Because the cost that we're interested in when we think about prices are typically variable cost or marginal cost. And that depends on what is long run, short run. So you need to go through each cost item and try to assess which are the ones that are relevant for your test. So a lot of work goes into this. And once you collected that data, once you've done that thinking, you then compare the prices to the cost and you say, okay, if this other competitor, which hypothetically are as efficient, would it have been able to recover its cost with the Intel's prices? And then you find yes or no. So in the case, you had economists on both sides doing very elaborate work, a very elaborate model, trying to figure this out. We fought it out. Intel lost. And then again, I said it was appealed, and I think I've lost track of who won in the end. But initially, that was the finding. Okay, so that's one example of how economics becomes very central in the assessment of competition law. The next area I'm going to touch on is probably the area I spend most of my time in, which is mergers. So this is when large firms merge together into one firm, and the concern is that it might create too much market power for the merged entity. And a bit similar to the abuse of dominant, the first step of the analysis is market shares. And that's really kind of the first filter that you look at. So you look at if market shares are too large, there might be an issue. It doesn't mean that there is an issue, but it means that it might be something you want to look into. So again, we spend a lot of time doing this. We collect data, we collect market shares, and try to calculate what is those numbers. Then once you have those market shares, you've identified the markets where there might be an issue, you then dig closer and try to see how does competition actually work here. You might conduct analysis of tender data, which I will show an example of shortly. You might do consumer surveys and analyze them. So you might go out and ask consumers, who do you see as close competitors in this market? Are these two firms that are merging, are they very close competitors, or are they actually quite different? And try to figure out what the effects of the merger would be. There's also a lot of qualitative analysis. You read documents, you read statements, in particular statements that the parties do themselves in their course of business. So you'll be very surprised that the companies do not really think about very often how their documents will affect the competition analysis. Because what often becomes important is you go through internal documents, internal presentation to management, and they say, oh, we need to buy this company because they're such a close competitor to us. Okay, now that looks very bad when it then goes in front of the authority. I think and hope companies start thinking about that, but that very often happens still, and then becomes difficult to explain. You then have, depending on the case and how interested the authorities are in the deal, you can make more sophisticated and advanced analysis. And those, I'm not going to go into detail here. If there are economists who work in the area, you'll be familiar. But there are something called guppies, which is a measure of the incentive for firms to raise prices, essentially, only looking at the supply side of the market. IPRs are illustrative price rises, which is the same thing, but where you combine supply and demand together to try to figure out what price changes would be. And then the big full-out option is a merger simulation, where you build a theoretical model of the market, you combine that with data, and then you simulate what the merger outcome would be. This option is relatively rare and only used for really, really big cases, because this one takes a lot of time and effort and is quite complex to work with. But sometimes in very big mergers, it's worth the effort of doing this. Then I have to mention RFIs, which is a very big part of the practical work. So the authorities, of course, will have a lot of questions. They will send requests for data, and then economists will be involved in preparing that data and preparing responses to RFIs, which is a big part of the work. And there can also be analysis where we as economists would produce reports to explain to the authority why a certain theory for why the merger would be anti-competitive might not hold, and why that is. And you often see authorities requesting that. So you might have an authority, they say, okay, we know that there are economists involved in this case. Can they please write a report for whether this theory is valid or not? And then they will assess whether they agree. So that's very common. Okay, so I'm going to go through two examples of merger cases and the type of economic work that we do. So this is a case I worked on, which was announced in August 2021 and was completed in September 22 with some divestments. So this is Parker Hannifin acquiring Meggitt. So these are both aerospace manufacturers. So they produce components to airplane engines. They produce airplane brakes, and basically different components to go on airplanes. Now these kind of markets are very much tender-based markets, which is because airlines, when they think about which wheels or which engine they're going to have on their plane, like you're going to have the same engine for a very long time until the plane goes out of production. Okay, so you typically don't want to change your engine very easily. So therefore you have a tender for a very long-term contract, 5 years, 10 years, a very long time. And what that means is that market shares become a bit less relevant. So depending on where you draw the lines on the market, it could be that there has only been 2 or 3 tenders in a given market over the last 10 years. And in that case, you might have one company having almost 100% market share, but that doesn't mean that there's no competition, because there could have still been very intense competition for those few projects. And in these cases, there will typically be very good data available. So the companies will record each opportunity, who was competing, what was the details, and you saw everything you'd want to know about those instances. So it's quite good data typically that economists can explore. So what we do in a case like this is we collect this data and then look closer into it about what does it tell you about competition. So in particular, when one party wins, so here if Parker had won a tender, then who else is typically competing? Who are the other bidders when Parker wins? And when Parker wins, then who is typically the runner-up? So that's a better type of information, because what we're really interested in is if there was a merger and Parker decided to raise its prices or raise its bids because of the merger, then who are the ones that would be winning otherwise? Because if Meggitt had been the one that is always number 2 whenever Parker wins, then Parker would realize, okay, if I were to raise prices, the person that would win in that case is Meggitt, and I now own Meggitt, so that's not a problem. And then they're very happy to raise their prices. And likewise the opposite, if Meggitt is never in the number 2, then the merger should not have a big impact on prices. So that's really what you're trying to see in this data. And you can also do analysis on margins, so you can look at what was the actual bid and what was the profit margins they got, and does that depend on who is competing on the merger. So there's a lot of things you can do by looking at such data. So another case which I thought was quite interesting is JD Sports career. So you may be familiar with JD Sports from the shopping malls here. Which I have seen. So JD Sports acquired a French retailer called Courier, which were quite similar to JD Sports in that they were active in sports-focused footwear and apparel. And what's interesting in retail in particular is that the market competition is local. Okay? So when we looked earlier at Parker and Meggitt, those markets are very global. Okay? It doesn't matter where the manufacturer is, everyone in the world is competing on tenders. When you look at retail competition, then you really look at very local areas. You look at one particular shopping mall, or you look at one particular store and think about where would customers go if they didn't go to that store? Which are the other stores they would consider going to? And this is a lot of economic data and analysis that goes into this. So what you do is you collect data on stores. So you make sure you have a data set of all the relevant stores, where they're located, how big they are, and so on. And then you calculate drive times typically between them. So how long does it take to drive from one store to the other? Now, once you have this data set, you then start to ask questions. So again, what's the relevant catchment size? So if you want to draw a circle around a store and say that all the stores within that circle are in the market, then how big is that circle? Because that can very much affect the competitive analysis, and that can affect where do you think you have an issue competition-wise. So, you know, is it a 10-minute drive from the store? Is it 20-minute drive? Is it 30-minute? Is it different in urban areas from rural areas? Is a shopping mall a market of its own? Would you go to a different shopping mall, or would you go to a different store in the same shopping mall? So these kind of questions. Another one which is interesting in retail is online sales. So do you consider online sales and in-store sales to be in the same market? So essentially, if JD Sports were to increase the prices in their stores, would you then go and buy online instead of in-store, or would you still be buying in-store? Or if you're buying online anyway, you wouldn't face that choice. But that's essentially the questions you start to ask. And then once you've defined these things, what is the market? Is online included? How big are the circles around the stores? You then look at all the local areas where both parties are present and try to figure out which are the areas in which the parties would become too strong. So you just have too many stores of the same merged entity. And the best way to answer all of these questions are customer surveys. So you'd ask customers in stores and ask them, if you didn't go to this store, which store would you go instead? If prices were 5% higher, would you change store or would you stay? Those kind of questions. You don't always have that, but especially in bigger cases you would. You can do an online version, so you might be able to send emails to everyone who buys online, or to say loyalty card holders and ask them. But then you got to be a bit careful with whether those responses are representative of how customers would actually behave. And then a final area where we also spend quite a bit of time is divestment scenarios. Because what happens in those cases is typically the authorities say, okay, now we've gone through the analysis, we define markets, we looked at all the areas, and we found that there are maybe 20 areas where it's just too big of an issue, it's not going to work. And then the authority will tell the parties, okay, either you don't do this merger at all, or you do the merger, but then you got to sell stores in these 20 areas. And there's different ways you can then sell stores. And this can even be a negotiation where the parties say, okay, fine, you know, I'll sell off these 10 stores, but I'm not going to sell off them, and you know. And there's a lot of economics that goes into this, and you recalculate market shares depending on which store you sell. In particular, if the areas are overlapping, because if you sell one store that are in 2 areas, you can then solve both problems with just one store. And the merging parties will be very happy with that. Rather than having to sell 2 stores, they can just sell 1 store. And then you do a lot of algorithmic modeling to see what is the most efficient way to solve competition problems. So again, it's very data-driven, very economics-driven analysis. All right, so the final area I was going to touch on is litigation cases. So, as I said, this is when private parties bring actions in national courts on the basis of a decision by an authority. And there's different analysis that goes into this. So, first of all, if it is a standalone infringement, so if an authority has not already decided that there is an infringement, then you got to prove that there is an infringement. And then it's just like any other case in front of an authority. It will be very similar analysis. If you have proven the infringement, you then move to the next step, which is plausibility of harm. So you ask the question, is it plausible that this actually had an effect on customers? Because even if there is an infringement, it doesn't need to be that there is an effect. So you can still break the law without actually harming anyone. So you got to go through that question. And this is typically a lot of theoretical work to think about, is this a valid mechanism by which customers would have been harmed? If you pass the plausibility test, you then go on to quantum. So now you say, okay, there was some harm, or it's plausible that there was some harm, so how much was that harm? And this is really the very data-heavy, very economics-heavy area, because this is very difficult for lawyers to answer without economists. So what you do is that you typically conduct overcharge regressions. So you basically look at prices while the infringement was ongoing and compare it to prices either before or after, and try to figure out, did the infringement raise prices, or if it's some other factor than prices. And you do this using econometric analysis, which means you try to control for other factors that influence prices. So for example, if it just turned out that the market was very high demand during that time, so if we were really in a very hot economic time period during that infringement, then it could be the prices were high just because the general market, general economy was being very hot. So you got to control for those things and try to figure out whether there was actually an overcharge in the end. And there's many other areas that goes into quantum that I'm not going to cover to any detail now. And then I just have to mention disclosure. So disclosure happens in many legal areas, but also in this area. And economists are actually, which almost surprised me, but yes, are very involved in this. In particular when it comes to justifications. So the economists will need to figure out, first of all, what data do we need? What do we need to ask from the other side? And why do we need it? And then you go to the court and say, we need this and this is why we need it. And then the other side will look at it and say, well, actually, you don't really need that. Or, you know, it's not proportional. So you have all these debates going back and forth with economists trying to explain what is necessary. So that's the standard in the UK, that it has to be necessary and proportional. So it's not way too much work for just little benefit. It has to be necessary and it needs to be proportional. So this, especially in the UK proceedings, this is a lot of work. So UK courts are very liberal with disclosure, which is one reason why a lot of claimants go to the UK, because they know they can get a lot of disclosure easily. So this is a very big part of the work. And the case I'm going to cover here is the biggest competition case that has been in EU competition law probably ever. So if you have followed any cases, you will be familiar with this case. I think half of the industry has been working on this case, including myself. So the aspect of the case is as follows. So in 2011, the European Commission carried out inspections at truck manufacturers across the EU, so the 6 largest truck manufacturers. And that was following a leniency application from MAN. So MAN, one of the manufacturers, went to the Commission and said, there has been something going on that maybe you should look into. And because they did that, they could not get any fines. Okay? There's a leniency process. 5 years later, the European Commission adopted a decision finding that there was an infringement. So the infringement was collusive agreements on pricing and gross price increases for medium and heavy trucks. And there was also conduct with respect to emission technologies. And this lasted for almost 15 years. So what this means is that everyone who bought a truck across Europe for a period of 15 years now had a possibility to bring suit in court and say, I want money back. Okay, and there was a lot of trucks sold in Europe over that 15-year period. So this is a very big case. So you take this case together with the damages directive, which made it so easy to bring cases, and you have a complete transformation of the industry just from this case alone. So there was many claims made across Europe, in particular in the UK and the Netherlands, which are jurisdictions where it's very easy to bring claims, and there's very sophisticated courts who's very used to dealing with these kind of cases. And needless to say, economists were very heavily involved on both sides, because there was a lot of work, especially on quantification of how much was the overcharge on these trucks. So, as I said, many claims are made in the UK, and in particular to the Specialized Competition Tribunal. So the UK has a court which specializes just in competition cases. So this court is very, very familiar with the issues. They have economists on the tribunal, so it's not just lawyers, it's lawyers and economists. So they're very well placed to deal with these kinds of cases. And the first claimant that came to the CAT was Royal Mail, so the post service in the UK. So they had bought trucks for them to deliver mail, essentially, and now they wanted money back. So in February 23, the CAT delivered its judgment. So this judgment was seen as very important because this was the first time the CAT said anything about final decisions on a lot of the issues in the case. And this was watched all across Europe. The courts all over Europe looked to the CAT because they know it's probably the most well-regarded court. And the proceedings before it was very sophisticated. There was a lot of economic analysis on both sides. There was a very, very long trial and hearing where the economists were testifying. There was cross-examination. There's something called a hot tub, where the experts sit together and debate in a very intense exchanges. All of this is live streamed, so you can go on the CAT website and look on live streams on these kind of things when they happen. And it can get quite heated and quite interesting. And it's, it's very advanced economics, so both from an economics and legal perspective, these things are quite fascinating. And yes, massive amount of time and money invested in this. So the areas that the court was addressing was what we already mentioned, so plausibility. Was it plausible that these trucks case raised prices for customers. What was the overcharge? So how much did truck prices rise by? Was there pass-on? So the idea with pass-on is that if you're here Royal Mail and you buy a truck for a higher price because of the infringement, then did Royal Mail then charge their customers a higher price? So basically, because truck prices would have been higher, the Royal Mail would have charged more for delivering mail. Because if they did, then they got some of the money back already and they can't sue for it. So that's a very central question. There's also a question of resale pass-on. So when Royal Mail resells the truck after a couple of years, would they got more money back when they resell the truck? Because if they did, likewise, they shouldn't claim the full amount. Loss of volume is even more complex and further down the line. So this is if Royal Mail resells at a higher price, so they sell stamps at a higher price, would they then sell fewer stamps? Because if they did, then they were harmed by that. So you can see you really go very far down the chain of causal events that happen and try to figure out what was the net impact on Royal Mail from this infringement. There was a very complex defense called the complements defense, which I just want to mention because it's quite interesting from an economics perspective. So this was based on economic theory, suggesting that if truck prices were higher, but there was no infringement on complements, so say trailers, then there is an economic theory that says that under certain conditions, the prices of trailers would have been lower. So the argument was that, okay, if there was higher truck prices, then trailer prices would have been lower, and therefore Royal Mail benefited from that. Okay. I'm not going to cover that in detail, but the court threw it out very aggressively, saying this was a waste of time, essentially. They were like, we can do a lot of analysis, but somewhere we need to draw the line, and this was not worth our time. But it was quite an interesting theory. And then there are more areas that goes into this. Again, I'm not going to cover in detail. You have volume of commerce, so how much would the trucks actually sold for, which is less obvious than you might think. And there's financing issues, there's tax issues as well. So just on what was found, so on the overcharge question, and this was the number everyone wanted to know. So everyone who's been involved in this case for many years. So remember, this is 23. This is 12 years after the case, the inspections. It's 7 years after the commission decision. And we're finally going to find out how much is this number. So as I said, both sides made very extensive econometric analysis, and the defendant's economist indicated essentially zero overcharge. So they said there is no evidence that prices had risen at all. Okay? You then had the claimant economists who, based on their analysis, said the truck prices have risen by 10%. Okay? And then you had this whole trial where they were debating, the court were asking questions, trying to figure out who won, basically, who was right. Was there 0 or was there 10? And when we finally got the number, after all these years, they took the middle. And it was quite disappointing from an economic perspective. In this sense, they essentially said, both sides sounds very reasonable. The arguments are very good on both sides. This is very hard for us. And they pretty much took half of it. That's not really the words they used, but that's the sense we got. So it was quite frustrating for the economists to see that outcome. The way they justified it is they essentially say that in these cases, when it's very difficult, there is a broad axe principle. So basically, when you don't really know, you just have to take something approximate. And they said 5% sounds reasonable. Okay. So there's definitely questions about what type of analysis is persuasive in these proceedings going forward. I don't think it means that economic analysis will not be needed. I think it definitely will be, but there's a very interesting to think about the implications of this. And the other thing I wanted to just mention is the pass-on judgment. So the pass-on judgment was also very interesting because this part of the judgment was not unanimous of the court. So there was a majority opinion and a dissenting opinion just on pass-on. And the tribunal here consisted of 3 people, 2 of which were lawyers and 1 was an economist. And the 2 lawyers wrote the majority opinion and the economist dissented. And this was very interesting because this really was typical of how economists and lawyers would often think. So in the majority opinion, the lawyers rejected that there was pass-on. They essentially said that we don't see any evidence of which price rise by Royal Mail that was caused by higher trucks prices. They essentially said we need to see very concrete evidence. There has to be a document saying that we rise prices on stamps because the trucks are so expensive. Or there has to be a pricing model, so some sort of pricing rule which automatically links truck prices to stamp prices or delivery prices and so on. So that we have to see this clear evidence, is what the lawyer said. The economist said, well, yes, but we're looking at a case which has gone on for a very long time. It was almost 15 years. And it's kind of economics 101, that if cost goes up, prices will also go up. And while it's true that if you're looking at a short time period and prices don't rise very often, then it is plausible that a cost increase may not actually have affected prices if prices never changed. But we're looking over a 15-year period and there was a cost increase. Economics 101 would suggest that prices will have risen at some point. We can't see exactly when, we can't see exactly which price rise it is, but it should have risen at some point, and that should count. So that was the economist view, thinking economic reasoning and what's reasonable, but the legal side required very more clear evidence and kind of smoking gun, this is what happened. And I think that was just quite an interesting take on how economists and lawyers see these things. All right, so I'm nearly done now, so I've gone through those details. I'm just briefly going to reflect on 2 more things. So one is the trends and developments in the field, and then just briefly implications for economics and law more broadly. So just what we see happening now is there's increasing quality and quantity of data. So it used to be that the data you got from the clients were very imperfect and you had to spend a lot of time cleaning them up. There is now way better data, which means you can spend less time on data cleaning and more on analysis, and there's more analysis that can be done. So it definitely increases the scope of what economists are able to do. I think there is, by now, at least in the EU and the UK, a very wide acceptance of economics argument and economic experts. So courts very well knows how economic experts, what role they play and what role economic arguments play. And that is taking time to get there, but I think by now it's at a very well established place, and that increases the value of economic arguments. There's development of new techniques of how to analyze economic issues. So there's, for example, machine learning. So I have now seen machine learning regressions instead of econometric regressions. So this is kind of niche, but it's something I would not have seen 5-10 years ago, and definitely new things. It's just to always, in our area, you need to keep in mind that when you have new techniques like this, you still need to be able to explain it to a court. So you have this black box issue of that if you can't explain precisely how it works, then it's not going to be accepted. And then just you have to mention AI. I mean, as in every field, this field also can be affected by AI and law more generally. And I think still early stages, but precisely how that plays out, what we will be able to do using AI tools are still an open question. I mean, one main area, of course, is document review of qualitative information, where AI is quite powerful in our area. Okay, and just some thoughts about how economics adds value to legal practice. So going beyond just competition law, but more broadly. And I think the first point is obviously whenever you need data analysis, when you need a lot of data to make your arguments, economists have a very important role to play and can add a lot of value. When the legal test of the legal argument is inherently economic, so like I said, in competition law, the topic is very much economics, then you definitely should use economic arguments. And economics is particularly good at assessing counterfactuals. So if something had not happened, what would have happened instead? So the economic tools are very well equipped to answer those questions. And I think it's important for lawyers to keep in mind that economists can often bring very fresh perspectives. So I think it definitely is the case that lawyers think a certain way and economists think a different way. And you can very often contribute to arguments from a different perspective. And then just finally on economic thinking in legal frameworks. So this is basically when you write legislation or when you think about what should the legal frameworks be, I think economics have an important role to play. In particular, as the aims of legislation is often to achieve particular economic outcomes. And then I think economists are very well placed to think about, well, what will the actual effect of those legislations be, and will they actually achieve the outcome which you set out to achieve? So when you see legislation that doesn't quite work out because it was not creating the outcomes they had intended, it's often because economic thinking was not appropriately captured. But then also to keep in mind, I think you often see economists and lawyers splitting on effects-based versus form-based approaches. So economists, this is very similar to the pass-on example I went through. Economists often think about what will the effect of this be, whereas lawyers often have a preference for more strict rules, which gives visibility for firms to see, okay, this is what the rule is going to be. It makes it easy to see in beforehand what the outcome will be and becomes very administrable. All right, so just to conclude, economics plays a very central role in competition law and how economists are very deeply involved. I pointed to some examples of how we use economics within this area. There's technological and methodological and data changes, which definitely changes the way we work right now. And I think economic thinking can help inform the legal framework, and economic analysis can be relevant to many areas of law. So I think that covers the talk. Thank you.
All right, thank you very much, Chris. I'm keeping track of our online participants as well. Well, we've got so far 700 views, which is great. A lot of people have joined us. Of course, they drop in and out. So thank you very much. That was very insightful. And I think, look, just want to share my feeling when I listen to you. I honestly so jealous of you. I mean, you are in a settings where you can add all this sort of analysis, where you can do this thing in a proper manner, and you have the whole ecosystem, which is something I want to discuss later as well. I mean, I've shared with you several times when we met earlier that, well, in this part of the world, especially here, the market is still pretty much underdeveloped, and there's so many fronts that we are, well, trying to work on. And as you also know, I mean, apart from teaching here, I'm also running this sort of VA partners, which is like Compass Lexecon in a very small scale, like economic consulting. So yeah, something that we are trying to do and create this ecosystem here. So let's start with maybe from participants in this room first. And I do have my set of questions, and if you see my note here, I have 12 initial lists, and after something coming up. But I want to get some sort of questions or, yeah, I mean, I want to collect questions from the room, or maybe for those who are joining us online, feel free to type in the chat. I'm looking at the chat box now, so I will see your question as well. But anyone would like to kick off with things before I start the discussion with Chris? Yes, please. Does it work? Some of them are running out of battery, so.
No one.
All right, thank you, Chris. We were actually colleagues until a couple of months ago. I was at a Compass Lexecon in the Brussels office, but then now I moved back and now based in Bangkok. Actually, I didn't work on the truck case, but I was curious when you said that the lawyers reject the pass-on and the pass-on defense and require some clear evidence. Because I work on the Mastercard Visa case, and the pass-on was central to our analysis.
Yeah.
So I was wondering what kind of evidence the lawyers were looking at. Was it econometrics analysis or documentation or anything that's more concrete than econometric analysis?
So you mean the evidence that they were looking at in the tax case?
Yeah.
There.
That they would accept that the pass-on did happen.
So, I mean, I think it was the examples I mentioned that, again, it needs to be a very clear evidence link. So, for example, if you have a very clear pricing model that the way delivery prices is set is a function of these things. You will have an Excel model, for example, which models the final price based on the inputs, and one of those inputs would be the truck price. Then that would give you the very clear evidence, or if you have those documents. I can't recall right now what the precise language or what the standard was, but that's kind of the idea of what they were looking for, that you need to have something very tangible to get that. I mean, I know in the case you mentioned, then pass-on is even more central, because that's kind of the main question of that case, whereas the pass-on here was more as a defense, which is why, you know, the burden of proof was very much on the defendant. And I think the stance that was taken was that the burden of proof was very high, and to overcome that, you needed these kind of details. Whether that same burden applies in the case you mentioned, I'm not too sure. I think, but that was kind of the broad idea of what they required.
Thank you.
Can I jump in here, because I would like to ask about this as well. I think this whole point is about the standard of proof as well. And if I understand correctly, well, again, especially when you talk about the offense that might consist of this kind of criminal charges or a harsh punishment, the standard of proof is going to be sort of left higher. And that's one point, which we sort of see the problem here as well, especially in the situation where you kind of, when you think about like people, I mean, involved like judges, we don't have, I mean, jurists or anything here, we just have judges, or like the commissioners. And when they considered, and we do criminalize some cartels here as well. And you can imagine that a lot of people involved in this sort of criminal process, they are familiar with sort of other kind of crimes rather than economic crime, I mean, let alone competition cases. And that creates this kind of discrepancy in terms of like to which level of burden you're going to prove. And that's one dimension. Another dimension, which is quite interesting as well, is I think you mentioned in your lecture as well, this discrepancy between the standard of proof between economists and lawyers, right? I mean, you prove beyond reasonable doubt. For lawyers, you need some level, and for economists, like wow. I mean, you keep saying economic 101, and that's kind of like the ground truth to us economists as well. Yeah. So, how do you really deal with this? I mean, I know that probably the problem is everywhere, but just to different degrees. But how do you, I mean, working as an economist, and you also have training in laws as well, in European law. So how do you really tackle this kind of problem? Which, again, I'm going to ask you about the way you communicate with other people, especially non-economists, in this sort of professional setting. Yeah, how do you really deal with it?
I mean, so first of all, on what the burden of proof should be, I mean, I think there's a distinction between cases where, because the question is what the default rule is. So yeah, if you don't meet the burden of proof, what is the default you fall back on? And I think when you think about criminal cases, if someone is considered innocent until proven otherwise, there you probably want a very high burden of proof, because we don't want to, you know, the risks of finding someone guilty when they're actually innocent is very higher than the other side. So you want a default rule that falls that way. I think when you're thinking of damages, then the default rule is kind of biased, right? It's falling towards one side, and it's not obvious to me why in damages proceedings you want the default rule which falls to one side rather than the other. So I think that's just one point that to think about with the default rules. How you address it in practice is that I think you pretty much have to accept the framework. So, you know, the legal burden of proof is what it is, and I don't think something as an economist you can affect. So you take the framework as given. You obviously need, when you present your evidence, you need to be very aware of what is the required burden of proof. Because if I then make statements which meet a lower burden of proof than what is required, those statements are not going to be helpful. They're not going to take you there. So I guess the main point is just to think about, when you make your arguments, will this meet that burden of proof or not? And if it's not meeting them, then you probably can't advance that argument, because you're just not going to meet the burden. So I think that's what you have to do in those cases.
Right. Yeah, this is so interesting, right? Because I think, yeah, I'm still open to, please, jump in. We're going to start our conversation. But I think, as you mentioned as well, one of the main roles of economists in all these, not just competition, our expertise is probably our ability to do with sort of counterfactual analysis, which actually lawyers are quite familiar with it in terms of like but-for tests and all these kind of tests. But we would come up with those sort of like more kind of quantitative tests, right? Like you mentioned about this as efficient competitor test or price cost test. And then eventually this kind of like counterfactual analysis would need to go through the same process of this sort of standard of proof, which is kind of like, I would imagine it's quite difficult. So I would translate that to the translation challenge, I think. Because your presentation, you talk about, the case of like price cost takes in Intel, bidding analysis in Parker, and you also, I couldn't remember if it was during your talk or our conversation, but you said that modeling is not, you are mathematical economist, so basically modeling and mathematics are your maybe first or if not second language. But in order to translate that and communicate with this, how do you navigate this sort of human element of translating the complex because you have to communicate with the legal team, the client, judges, and especially so that's one thing. How do you really sort of communicate? Customize your communication. That's the first thing, okay? But I want to go a bit further and ask you about this. You mentioned about this sort of narrative, right? You mentioned about this sort of narrative. And we know that, sometimes when we analyze this data, a lot of data, especially when it involves this sort of statistical and you have to make a call. And at times you represent different side of the story, right? You kind of like, sometimes we represent the client on the plaintiff, sometimes we represent on the opposite. But at the same time, being economic consultant maybe, I think we sort of probably serve kind of a distinct role. When you compare to lawyers in particular, So first thing is communication, of course, right, within your team and also with the people. But again, we know that there's a room, a degree of freedom, if you like, for this sort of narrative customization to tell the story, like online and offline. You mentioned about market, right, retail. The number will not tell you like 100% same market or 0% same market. It's going to be somewhere in between that you have to narrate. And of course, if you represent the one that you want the market to be a bit big, you would have this sort of temptation to narrate it in such a way that the market is bigger, if you can, but it will not compromise your integrity. So yeah, I mean, two sub-questions. The first one is communication in general, and the second one is this kind of position about neutrality, integrity, being kind of impartiality in giving this sort of economic analysis. How do you really deal with this in practice?
Right. Okay, so on how to approach the communication. I mean, first of all, yes, I didn't really hesitate when you asked me what's most important, because to me it is the explanations. I mean, you need a lot of things in this area. You need your economics, you need substance to be right, but at the end of the day, it doesn't matter if you're right if the person you're communicating to doesn't understand that. So that's why I'm not hesitating. You really, really need that explanation skills, and that really is the most important things. Then how you do it is, I mean, essentially just trying to keep things simple. Try to speak it in the language of the person you're communicating to. So when you have academic economists speaking to each other, you can speak with equations. Okay, you cannot speak with equations to judges. And everything can always be broken down to something very simple. Now, you might seem, where you start off, things might seem very complicated. You have a machine learning regression, you have econometric analysis, all of things is very complex. But at the end of the day, everything can be broken down into something very simple. And what you need to do is to be very disciplined and force yourself to identify what are those simple blocks of the story you're trying to tell. And yes, so it sort of requires discipline and trying to get there. And the idea is never to try to sound as you're doing something very complex, you're very smart, you're trying to impress by doing, that's not going to fly. What you need is something simple, persuasive. It needs to be a very story, like a narrative. It is a simple story in very simple blocks of what you're trying to get across. Once you've done that first story, there might be follow-up questions, and the person you're communicating to might want to figure out details. But to get the point across, you just got to go to the simple building blocks, which to me is very similar to teaching. So that's why my teaching experience from my PhD has been incredibly useful, because again, same thing, you're really trying to break things down into logical, simple blocks. So I think that's what I would emphasize in that area.
Could you give us like one sort of more concrete experience? I know, I mean, maybe a very bad one from the other people that you have encountered, or maybe the good one that you or maybe you have learned from someone else, like, yeah, actually you can do this, but you do this, you explain this thing this way instead, and that is so good. Anything off the top of your head?
So I'm not sure I remember the exact details, but say a context in which this comes up is when you're working with a barrister in the UK. So in the UK court system, you have solicitors and barristers. So the barristers only come in when you're very close to a hearing, because then they are the ones presenting to the court. And that's quite an interesting process, because day to day you would work with the solicitors, that's the lawyers you would usually work with. Then the barrister, not involved at all, and then before the hearing the barrister comes in and has to learn the full case. Okay, and it is my job then to explain to the barrister the whole case in a very short amount of time. And so I've been working on quite theoretical models, quite advanced mathematics, and then have calls, quite long calls, with a barrister to go through and explain, this is what it means, this is what you should take away from this. So basically to help the barrister translate these conclusions from a mathematical model into language for the court, and then go through those details. I think that's one example.
Well, anything? Otherwise I will keep talking. Anything? How hard do you work? Oh, that is quite a surprising question coming from you.
Very hard.
Very hard.
Very hard.
Yeah. Well, let's say you are the VP of one of the largest law and economic consulting. Has this ever happened to you that your potential client or even like judges or people just say, why do we need economic analysis? In competition it's quite clear, right? It's kind of like become the standard of the field. But you also mentioned about this sort of damages calculation in other cases as well, valuation and orders of arbitration where valuation come into it. What would be your best way to think about it? Like why? In which circumstance is great, in which circumstance is probably okay?
Yeah, you often do on the margin, right? So there could be you might be involved in a project and there might be pieces of work of that project where it's not entirely clear whether economists should be involved. So then you might have that discussion. And there definitely are areas, I think I mentioned the FSR regulation, so foreign subsidies regulation, which is something recent, and I think it's still being figured out how involved economists should be. So I think that's kind of an open question. But taking that as an example, so a lot of the analysis in the FSR area is whether a contract or say a loan that was given to a company were giving on market terms. So basically if you have a loan to a company, was this loan a fair market contract, or is this essentially a subsidy which then needs to be assessed under the subsidy regulation? That's a question lawyers might try to answer without economists. But it can certainly be more forceful and you can have more clear evidence base if an economist gets involved and makes an economic opinion on how those contracts compare to fair market value. So I think it's quite clear that you'll then have a much stronger base for your argument if you were to bring in economic opinion. So then you have to assess that trade-off of whether it's enough value to bring in the economist, but I think that's how you can explain the value which economics can bring.
Yeah, but again, I think you kind of see this necessity, and I want to take you back back to Thailand maybe, or maybe some other jurisdictions as well. You did touch upon this sort of factor of judges as well. You mentioned about the tribunal, of the competition tribunal of the of CAT, which has even economists, and they are very knowledgeable. And that is kind of like, well, look, it's kind of like demand pool, if you like. It's kind of like, because you need someone that want to listen to all this kind of analysis, right? And judges are one of the main sort of demands of this sort of rigorous economic. You also mentioned as well in your talk that there is a fine sort of tuning that you have to do, like to which extent that regulator would like to read the complication or the complexity of the analysis. That's probably one thing, but how else? What do you think is kind of like a necessary condition that we should really have in one setting or one ecosystem in order to build this whole practice?
Yes, that's a difficult question. It's obviously taken a long time to get to where we are in Europe and the UK. I think what you mentioned of authorities and courts being receptive to economic analysis is obviously very key. I think how you get there is a difficult question, right? As you say, I think there has to be kind of a culture of acceptance of the value that economic expert evidence can bring among courts and authorities, but also, I guess, among the legal community, that there's a realization that bringing in economic evidence and arguments can add force to legal arguments as well. Then how you set off that trigger of moving in that direction, I think is the the $1,000,000 question, but I think that's
yeah,
that's
I
what
know.
needs to happen.
Well, probably to add to your point, you touched two things. One thing is you talk about legislation process in which economists should get involved. We do have this thing called Section 77 of the Constitution of Thailand, which in it there's an attempt that say that every single legislation you should do this sort of impact assessment. Right. And that's very much regulatory impact assessment. And we have this sort of legislation follow-up, which we got this RA Act, if you like, since 2019. So probably that kind of like economic back legislation would eventually lead to the user of it, which of course includes judges. That at least one of my hopes. Another thing that you also mentioned about, and I think it's quite interesting, is when you talk about private enforcement, it is pretty much where, I understand correctly, where economists, and which I'm going to ask you later about this sort of duo, but it's pretty much a stage in which this sort of economic analysis works really well, because now it's this sort of like balancing between two sides, right? The court, which is like, and there's going to be the duel of like two teams of economists sort of fighting. Interestingly, we don't have that many here. I would say just a handful of them. After almost like we enact this current I'm talking about Competition Act in particular. Yeah. We enacted it in 2017. Until now, it's almost 9 years. Is it? Oh, it's almost 9 years, right? We don't have that yet. In the draft that was just sent to the Parliament, they try to increase the incentive by giving this sort of like punitive damages and try to make it more sort of lucrative for the plaintiff to go to. Yeah, so you have had experience in it, in this kind of like private enforcement. And this again will be probably so difficult for you to analyze because you don't know the context here, but just from your observation in your jurisdiction that you are active, what kind of factors that really contribute to this kind of like private enforcement, because it is super important. Yeah.
So you mean the use of economics, or just the
I think
bringing
both.
cases
maybe
more
maybe
broadly?
two stages. Yeah, one is the prevalence of the private enforcement, and the second one is let's talk about duo, right? Let's talk about duo between economists.
Yeah, I mean the really big thing that happened in the EU was the damages directive, which in particular, yes, made two things. So one is the fact that you can bring follow-on damages from an infringement, which then makes it a lot easier because proving an infringement from scratch in private courts is a big undertaking. We don't have that in the current one. Yeah, so that obviously is a very big hurdle if you need to invest the legal cost in first passing that step before you can go to the next one. So that's a very big one. And the other one, which always matters for whether you want to bring suits, are disclosure rules, because it's very hard to prove, especially if you want to bring abuse cases. So if you're claiming that somebody else, the other side, well, also in agreement cases, you really need disclosure, right? If you want to prove your case, you're going to need materials from the other side. And the rules around disclosure can vary quite a lot across jurisdictions and really determine how likely you are to be successful in bringing your claim. So I'm not familiar with the disclosure rules in Thailand, but that's another area which definitely have a big impact on whether you want to bring your claims.
Yeah, right. But by that you mean discovery process?
Discovery, yes.
All right.
Yes,
all right.
discovery.
Yeah. And that go back again to the understanding of judges, right? I mean, you're gonna sort of give a permission to certain kind of evidence just because you know why, and if you don't, you can't imagine why, then you just say no, it's unnecessary.
Yeah,
right.
Exactly.
It's kind of like a vicious cycle, is it? Right. Any question from the floor or from home? Okay, and you haven't really addressed this sort of, because you talk about adversarial model, right? And we talk about dueling experts from two sides. What do you think about it? Is it like, I mean, some people say it's a problem, some people say it's actually a solution, it's actually good. What is your view on that?
Well, so the adversarial model is very well developed, as I said, so especially UK courts, this is kind of what the system is.
You might want to give a bit of background to the audience. What is it?
So the idea is you have two different sides, right? So you have one side often bringing a claim, and then you have a defendant side of the same case. And then both sides would hire their own lawyers, and they would also hire their own economists. So you have economists working for each side and then bringing evidence for either side. Now, the really big power of this model is obviously there is a very strong incentive for each side to identify the evidence that helps support their side, which gives you kind of good confidence that the evidence that are relevant will be part of the case. So I think that's the really big power of the adversarial model, that you really have two sides that have very strong interest to make sure everything is on the table that the court would want to know. So I think that's obviously the very strong power of it. Now, the economists have a slightly different role to lawyers, in the sense that the economists are independent experts, and they have a duty to the court of assisting the court. And that is a very important duty, which the economists in front of the courts take very seriously. And of course, you have a very strong interest as an independent expert to preserve your reputation for future cases. And I mean, I think this model is something that works well, and I think the courts see economic experts as very valuable. So in UK court judgments, you would typically have a section where they provide comment on the economic experts. And they say whether they found the expert useful, whether they found the expert to be slightly biased towards one side. So you kind of get a review as an expert, which is quite helpful. And I think I'm going to quote this because I sent it to you in advance as well when we had some discussions. So there was recently quite an interesting judgment in the CAT where they were commenting on economic experts. And one of the experts in this case was Professor Tommaso Valletti, who, for those familiar with the field, will be familiar with him. So he's a very outspoken expert and very prominent expert in this area. So according to the judgment, he made a lot of comments about the other side's economists as being hired guns. That was not his words, but that's how the courts described it. And the court's comment on Professor Valletti's views were as follows. We deprecate such comments which evince a degree of naivety and the lack of understanding of the litigation process on the part of Professor Valletti. The process before this tribunal is an adversarial one, where experts advance opposing views which are appropriately tested in cross-examination. We consider Professor Valletti's criticism of other experts ill-advised and wrong. So I think that was quite a strong statement from the court of the value of the adversarial process, and that they see value in experts because there is a very thorough process by which you examine the arguments on the merits of them. So as long as you have that, I think it is a very powerful process. It does require, I guess, quite a bit of sophistication on the side of the court, that they have proper means by which to test and assess arguments. So if there are arguments that are being brought that are not really sound, then that will get called out. If you have a less sophisticated court, you might have those issues a bit more. But given that you have that, I think it's a very powerful and well-functioning system.
Yeah, because I think we are more familiar with having economists as like expert witness, and that sounds like you use by the court like purely. And, it is quite a bit less often we see economists representing a different sort of side or parties in the case, which is I think something that we will see more and more. Okay, maybe my two last points before we turn to the floor again. One thing is, let's zoom out a bit. I mean, all this the sort of discussion, I really want to sort of shed light on how you really tackle these sort of challenges in practice. But let's see the market a little bit, right? You are a VP now. You have not just look at the cases, but you look at the market as well. I mean, of these sort of economic consulting. how is this like? How is this like maybe in the UK or Europe? I mean, I don't know which metrics would represent it well, but I just would like to see the landscape of the market. Like, what is the size of it? Out of competition cases, 100 cases, you as an economic consultants would involve in, say, 90% of them, or what? Yeah, I mean, I just would like to, for the audience, because we have some students, which of course the next one I'm going to ask about sort of characteristics or skills that they need. But let's talk about the market in general first. Yeah.
Yes, I mean, I can't give you numbers. I can give
it's fine.
give you.
I find it hard to come up with the numbers as well. Just would like to see the sort of the sense of it. Yeah.
Yeah, I mean, it's a comment.
If I quickly jump in, I just look at some numbers at the merger filing at the European Commission. There were around 200 to 400 each year. But of course, economists won't get involved in all of them. But that's, I guess, a ballpark number, 200 to 400. Then there will be some pre-merger assessment that we got involved that didn't get brought up into the public. So, like Kristofer, it's kind of hard to guess exactly the numbers of cases.
Yeah, and that's mergers, and then you have litigation.
Yeah.
Everywhere you have arbitration cases, which doesn't even get disclosed. You know, those never became public. So it's big. There's a lot. There's a lot of consultancies out there. So it's there's a lot of activity going on. I'd say most litigation cases that are competition claims, I think you'd have economists involved. Maybe not for small cases, but generally any kind of larger case. Yes, what I'd say on the market, maybe I don't know if this is to your question, but this is a slightly different role of the way it works in the US versus Europe, UK, in the sense that in the US you often have academics being the names they are the ones testifying. So you have the Nobel Prize winning professors from the US being the ones sitting in court. Whereas in Europe, it's more professional economists that are more used to working on these cases specifically. Just one difference.
Yeah, quite different. I think probably one proxy is judging from your lady's question, like how hard do you work? That's probably a good crude proxy to use. And the answer is you work really hard, so there must be so many cases. Right. Let's talk about maybe one last thing. Skills, right? We have some students sitting here with us and also, I believe, joining us online. What kind of skills? I mean, if I'm going to have to sort of polish my, Swiss knife or skills set, and then I would file an application to Compass Lexecon, what kind of skills are you looking at? If I were prepared, I know that, economic consulting is super interesting. Yeah, and I really want to be one of you. What kind of things do you would advise?
Right, yeah. So I can't speak for Compass Lexecon. I'm speaking for myself, from my
for yourself,
my own experience. I mean, first of all, having good economics and technical skills is kind of a necessary requirement, but that's kind of a need to have. But the main point beyond that is what I already pointed to earlier, is being able to explain things clearly. And being able to focus on that storytelling and being able to simplify things and show that you not just do the technical things, but you know what they actually mean. And I think that's a big difference between going into academia and then going into this kind of work. To show that you can't just sit down, do the numbers, do that hard academic work, but you can actually take that into the real world, because that's a more difficult skill. There's a lot of people who can derive the first order conditions of the Cournot model. There's not that many people who can easily explain what that means, right? And I think that's something I think is very important for work in this industry.
How do you train yourself to be those few people who can actually simplify things and communicate really well?
So I think it's with everything. You look at it, how it's done well, and try to mimic it, right? So you look at Things that are very well explained, you can look at reports. Sometimes there are public reports out there that try to explain economics complex simply and really force yourself, again, that discipline to take something complex and really explain it simply. You can, I mean, I mentioned the CAT hearings that are being live streamed. Excellent learning source, you know, to go there and see how the economic experts are testifying. How do they respond to questions? These things are very, very complex, and they have to explain it, you know, straight on the floor to a non-economist, right? And then you can learn from that.
And you can watch it in retrospect.
Yes, yes. So,
yeah.
Not that I'm not sure about, but if you catch it live, you can.
Right.
Yeah.
I could come up with one possibility is to talk with this sort of chatbots, right? And just ask them like, yeah, tell me like you explain to high school students. That's something I use a lot, honestly. When I want to explain some sort of not very, but a little bit like more complicated ideas to my students, especially in a very non-technical manner.
Yeah, just check your sources after. Yes.
But be sure it's correct.
Yes.
So the very beginning is you need to understand the things first before you use this method.
Yes.
Yeah. Right. Maybe one last chance. Any questions or any comments? Yes, please.
What do you think about political pressures these days on competition agencies? Is it rising? Does it really affect the decisions? Like pre-Vodafone?
Is it the CMA you're thinking of here?
Or in general? In general. Let's not name any specific agencies.
Yeah. I mean, yes, there is currently a lot of discussion around the CMA. Earlier this year, the head of the CMA got fired, essentially, by the government, which is very unusual. The government had put a lot of pressure on the CMA to be more pro-growth. I don't want to express too much opinions here, but just to say there is a big debate right now, you know, what is pro-growth? Because I thought competition policy was meant to create growth, so I don't know why reducing competition enforcement would help with that. I would say yes, the CMA's behavior at the moment seems affected by political pressure, the extent to which we're finding out as we speak. So that's certainly something that is being discussed in the industry right now. I think at European level, not as stark, but I think even there, more recently, you know, there's discussion about creating European champions as something that politicians seem to like, which from a competition policy perspective is not as obvious. So I'd say yes, that's a very interesting topic right now, which, you know, as a practitioner working on the individual cases is something that's not really within your framework, but certainly in practice it is something that is affecting things, and I think quite interesting to see how that develops.
I mean, I would like to share as well. I think it's probably about, in my opinion, it's about policy space as well. Right? It's kind of like we talk about this kind of influence of industrial policy, which has become more and more popular everywhere in the world, and that sort of eat up our space of a competition policy as well. Yeah, and again, I actually was just like wrapping up a project which is talking about policy advocacy, right? Like I don't know much about the activeness of CMA, but I know that in some jurisdictions like South Korea or not in Thailand, but some countries in Europe as well, that this kind of very active role of competition authorities to really talk to the government and tell them that, look, all your other policies are actually against competition and you should adjust it. So I think probably the competition authority themselves should sort of fight back against this sort of pressure against the use of the competition policy. So yeah, I mean, that is something we sort of underutilize here in Thailand as well, which I think we should do better. Yeah, but sort of agree. I mean, it's always this sort of war between competitive process and other things, right? Yeah. All right, Chris, I wish I had more time. And it's not that easy to find you here in Bangkok. I'm trying to convince you too to come over more often. Next time, maybe teaching some of my classes. But it's truly our pleasure and honor to welcome you to the Faculty of Law, Chulalongkorn University. I believe that our students, our participants, our staff, and all participants who is joining us online and who have joined us online have learned a lot about this law and economic practice, economic consulting, what you have been doing on a daily basis, and you have been working hard, as your lady asked you. I think we learned a lot, so it's truly our honor, and thank you very much for being with us today.
No, thank you for having me. Thanks everyone for coming. Thanks for the invitation and the discussion.
Thank you. So, good round of applause. Right, so we'd like to conclude the session. Thank you very much for joining us. Please stay tuned, and I think we are going to have more and more seminar in the rest of the academic year, and please wait and see our announcement what the next one will be. Thank you very much, everyone. Goodbye.